Ready? Start. He has already admitted orally that he is ready to make the payment of the check amount to the complainant in 4 installments. Stop. It was further averred that the petitioner is a very clever person and the possibility of him fabricating CD cannot be ruled out in these days of advanced electronic and computerized systems. Stop. Since the requirement of the Indian Evidence Act has not been complied with while filing the application, therefore the petitioner could not be allowed to create false evidence through the articles mentioned in the application. Stop. Resultantly, it was averred in the reply to the application that the complainant had already raised his objection qua the mode of proof of the articles Exhibit D1 and Exhibit D2. Therefore, there is no basis for giving direction for voice samples of the complainant. Stop. Hence, the prayer was made for dismissal of the application. Stop. After considering the rival contentions, the Judicial Magistrate First Class Amritsar wide his impugned order dated 2/8/2018 dismissed the application filed by the present petitioner. Stop. While dismissing the application, the trial court has recorded that it is not mentioned by the applicant as to by what device or instrument the recording was done, and the accused has not placed on record even affidavit and certificate regarding authenticity of the recording. Stop. It was further recorded by the trial court that no date, month or time of recording is mentioned by the applicant. Stop. Still further, the trial court recorded that even the cross-examination of the complainant by the accused / petitioner reveals that the accused had not even put any question of the complainant regarding the recording of any conversation which has now been sought to be produced on record. Stop. The trial court also recorded that the applicant himself has admitted as having issued a check to the complainant relating to some committee which is allegedly being run by the complainant. Stop. Still further, the applicant claims the presence of 8 persons at the time of recording. However, not even a single person has been examined by the applicant to prove such conversation. Stop. Resultantly, the trial court held that the authenticity of the recording has not even been remotely claimed and proved by the applicant. Stop. Therefore, the same cannot be taken to be the evidence which might be requiring its comparison with the voice sample of the complainant. Stop. The trial court also recorded that the case is pending for defense evidence since 13/12/2017 and the present application has been filed only as a modality of delaying the trial. Stop. As a result, the application filed by the petitioner was dismissed. Stop. That is how the present petition has come before this court challenging the order dated 2/8/2018. Stop para. Counsel for the petitioner argued that the accused has a right to fair trial. Stop. In exercise of his right to defend himself, the petitioner is entitled to lead the evidence of his choice. Stop. Counsel has relied upon judgment of the Honorable Supreme Court to contend that since there is a preemption raised under Section 139 of NI Act, therefore an opportunity must be granted to the accused for adducing evidence in rebuttal of the prosecution. Stop. The accused must be granted full opportunity to rebut the presumption raised against him. Stop. Counsel has further contended that the accused can be permitted to examine the handwriting expert as desired by him. Stop and over.